In a world of rebellion, insurrection, rioting, the city of Los Angeles is a lawless hellscape populated by demented criminals, depraved super predators, and terrifying immigrants hell-bent on destroying our way of life and undoing a century's worth of progress. Oops, my bad. Those are pictures from Mar-a-Lago. LA is more or less going about its business like normal, which is no mean feat when your city is under military occupation by thousands of Marines and National Guard troops parked there to deal with a so-called emergency. And by emergency, we mean roving squads of masked ICE troops with automatic weapons getting yelled at and filmed everywhere they go.
The soldiers and Marines are still very much a necessary part of what's going on here because they're worried that it's going to flare back up.
Apparently, the potential that people might riot is an emergency because protests are temporary, but military occupations are forever. At that same press conference, Vance snarked that Jose Padilla decided not to show up because there wasn't a theater.
Well, I was hoping Jose Padilla would be here to ask a question.
Jose Padilla was a domestic terrorist convicted of plotting to set off a dirty bomb in 2007. Alex Padilla is the senior senator from California. Vance was telling a joke about the FBI wrestling Senator Padilla to the ground and handcuffing him for the crime of asking Homeland Security Secretary Kristi Noem a question. And by the way, Vance served for 4 years in the Senate with Senator Padilla. You'd think he knows his name. But to be fair, Vance does get stuff mixed up sometimes, like in 2016 when he called Trump America's Hitler. Oopsie doodle. For a little while, it looked like those troops might have to pack up and go home after a federal judge ruled that Trump had exceeded his authority to deploy them there. But then the Ninth Circuit swooped in and said that Trump can do pretty much what he pleases with the National Guard. So now it looks like the sunny city of LA will continue to host 4,000 troops loitering around federal buildings while wielding assault rifles, just generally adding an air of menacing authoritarianism to the city. In early June, President Trump promised that the greatest mass deportation in history would begin in LA, Chicago, and New York. Why there? Well, these cities are the core of the Democrat power center where they use illegal aliens to expand their voter base, cheat in elections, and grow the welfare state, robbing good-paying jobs and benefits from hardworking American citizens. You don't hear about sanctuary cities in our heartland. And if you believe that, I've got a dairy farm in Iowa to sell you. Masked men in unmarked cars with no license plates descended on the city and started snatching up anyone who couldn't prove their citizenship on the spot. ICE claimed that 3 out of 4 people it arrested were criminals, the worst of the worst. But in reality, only about 10% of the people ICE arrested between October of 2024 and May of 2025 had serious criminal convictions. The vast majority were just garment workers or car wash attendants or day laborers. Apparently, Trump's great replacement guru Stephen Miller told ICE agents that just arresting criminals wasn't going to cut it. They needed to get out there and start grabbing up people at 7-Eleven and Home Depot. When ICE reached the unheard-of threshold of 2,200 immigrants arrested in a single day, Stephen Miller demanded that they make it 3,000.
Under President Trump's leadership, we are looking to set a goal of a minimum of 3,000 arrests for ICE every day, and President Trump is going to keep pushing to get that number up higher each and every single day so we can get all of the Biden illegals that were flooded into our country for 4 years out of our country.
And so on the weekend, which began on Friday, June 6th, ICE descended on heavily Latino neighborhoods in the LA metro area and started grabbing people and stuffing them into vans. They even took the ice cream man in Culver City. Unsurprisingly, this provoked a major backlash as people with jobs and families and long-standing ties to the community were snatched off the street. Protesters flooded the city demanding that ICE go home. Now, most witnesses on the ground, including news media and city officials, reported that the protests were largely peaceful. But there were some isolated instances of violence and property damages. A few driverless cars were set on fire. Some protesters hurled rocks, bottles, or concrete at law enforcement or law enforcement vehicles. Some businesses and federal buildings were defaced. And there was a section of Highway 101 that was temporarily blocked by a makeshift barrier. Almost immediately, the Los Angeles Police Department got the violence under control. And LA has plenty of experience with actual riots, including the Rodney King riots in 1992, which was the last time a president ordered the deployment of the National Guard. The LAPD has also got a ready supply of flashbangs and rubber bullets and tear gas, which they quickly deployed on the protesters. But the fact that the LAPD quickly put down the pockets of violence did not matter to Trump, who has promised since his campaign days to use the military against civilians. In fact, he had the military tear gas protesters in 2020 so he could trespass on church property and take a picture of himself holding a Bible upside down. This time, Trump and his supporters in the conservative news bubble portrayed Los Angeles as a post-apocalyptic hellscape. Just look at these burning robot cars and Mexican flags. According to Trump, if he hadn't sent in the military, LA would be burning to the ground again. So on June 7th, he put out a memo ordering Secretary of Defense Pete Hegseth to federalize members of California's National Guard to temporarily protect ICE and other United States government personnel who are performing federal functions, including the enforcement of federal law, and to protect federal property at locations where protests against these functions are occurring or are likely to occur based on current threat assessments and planned operations. Again, the possibility of protest is treated as an emergency. And in fact, Trump says that any protest that inhibits ICE from carrying out its duties constitutes a form of rebellion against the authority of the government of the United States, which is a wild thing to say. Think of all the acts of civil disobedience you learned about in school, from Rosa Parks to that iconic image of the man standing in front of the tanks in Tiananmen Square. That is clearly not rebellion. But Pete Hegseth wasn't worried about all that. So on June 7th, he issued a memo to the Adjutant General of the California National Guard purporting to call 2,000 members of the state militia into federal service for 60 days. 2 days later, he federalized another 2,000 National Guardsmen and deployed a battalion of 700 Marines to LA for good measure. But that appears to have been the extent of Hegseth's planning. The Guardsmen were soon pictured sleeping on the floor without adequate housing or food. But in the Secretary's defense, beer is tasty. California Attorney General Rob Bonta was prepared. And on June 9th, he filed a complaint in the Northern District of California alleging that the federalization of the state's guard was illegal. He also asked for a temporary restraining order returning the troops to the control of California Governor Gavin Newsom. The president's memo federalizing the guard relied on 10 U.S.C. Section 12406, and the main thrust of the state's argument is that the conditions laid out in that statute were not met. Specifically, the law allows the president to call into federal service members and units of the National Guard of any state in cases of foreign invasion, actual rebellion, or when he is unable with the regular forces to execute the laws of the United States. The state argues that there was no invasion, no rebellion, and no inability to execute the law since ICE continued arresting immigrants throughout the protest. And since the law requires that orders for these purposes shall be issued through the governors of the states, they argued that going around Governor Newsom to the Adjutant General was illegal as well. California made various other arguments about the Posse Comitatus Act, a federal law which bars the use of the military for civilian law enforcement. They warned that violation of the Posse Comitatus Act is imminent, if not already underway. The state also pointed out that a 60-day deployment was untethered to any actual emergency and indicates that the National Guard may be compelled to accompany immigration enforcement on its missions in any location with potentially dissenting residents. Is Hegseth planning to send the California Guard to other states to police protesters as a roaming nationwide police force? Because that would be very illegal. Newsom argued that Trump's federalization of the National Guard was a violation of the 10th Amendment, which specifies that the powers not so delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. They argued that parking the National Guard in LA to quell a non-existent uprising was a waste of state resources, particularly during wildfire season, which, unlike a handful of Molotov cocktail-wielding hellions and burning Waymos, actually constitutes a serious threat. The Trump administration's response was basically to say that the court lacked jurisdiction because determining whether there's an emergency is a political determination left to the president's exclusive discretion. If the president says there's a rebellion, there's a rebellion. If he says that LA has been reduced to a Mad Max-style hellscape, then it's this, not this, and no one can say otherwise. You may recognize this argument from the Alien Enemies Act cases where the president simply declared that the U.S. is being invaded by criminal gangs sent by the government of Venezuela, or when he announced that he was taking Congress's power over the tariffs to deal with the emergency of trade deficits. Being president means you can just define reality by executive fiat, which is probably why the table of contents and table of authorities in Trump's team's brief was entirely blank. I'm kidding. It was just a screw up because half the Justice Department quit already, and it's like 2 lawyers left in the building, and those guys haven't slept since January. Basically, the DOJ argued that a handful of kids throwing rocks and tagging federal buildings with graffiti made it impossible for ICE to execute the law, and so the federalization of the Guard is justified under the third prong of Section 12406. And they pointed to the line of Hegseth's memo saying, through the office of the governor, as evidence that the Defense Department had satisfied the statute by working through the governor via his adjutant general. On June 12th, Judge Charles Breyer issued a temporary restraining order ruling that the president's actions were illegal, both exceeding the scope of his statutory authority and violating the 10th Amendment to the United States Constitution. He found that Trump hadn't satisfied any of the requirements under Section 12406 and scoffed at the claim that ICE had been unable to execute the laws. He pointed out that ICE arrested 44 people on June 6 alone and detained nearly double that. Whether ICE could have detained more people in the absence of the protests is mere conjecture, but even assuming that defendants are correct, the statute does not allow for the federalizing of the National Guard when the president faces obstacles that cause him to underperform in executing the laws. Nor does the statute allow for the federalizing of the National Guard when the president faces some risk in executing the laws, though, of course, federal employees should never have to fear danger when performing their jobs. And he warned that characterizing the exercise of the First Amendment right to protest as rebellion was dangerously broad because individuals' right to protest the government is one of the fundamental rights protected by the First Amendment, and just because some stray bad actors go too far does not wipe out that right for everyone. The idea that protesters can so quickly cross the line between protected conduct and rebellion against the authority of the government of the United States is untenable and dangerous. The judge was equally unimpressed with the argument that simply by stamping the words "through the governor" on top of Hegseth's memo met the statutory standard of issuing orders through the governor. He said that this reading of the law strains credibility, so not only had Trump not met any of the three factual circumstances required to invoke Section 12406, but he hadn't met the procedural requirements either. So Judge Breyer issued a temporary restraining order directing Hegseth to return control of the guardsmen to Governor Newsom, and he scheduled a hearing on the preliminary injunction for June 20th. Remember, a TRO lasts for 14 days. It's supposed to kind of freeze things in place with no one getting irreparably harmed until the court can hear from all parties and make a reasoned judgment. A preliminary injunction lasts through the trial itself. And now this is going to become important. Judge Breyer put off the issue of whether the government had violated the Posse Comitatus Act for the preliminary injunction hearing. He said basically, we'll know what the government intends to do with these troops in a week. Because remember, it wasn't just the National Guard on the streets. Hegseth had Marines out there too. So Judge Breyer said, come back in a week and tell me if the government is using these troops to arrest people in violation of the Posse Comitatus Act. Now, TROs are not immediately appealable because they're meant to be an extraordinary and very temporary remedy. You're supposed to wait for the PI to go running to the circuit court. But the Trump administration has just been appealing everything, and pretty successfully. They've even gotten the Supreme Court to leap in and block TROs they don't like. And this time was no exception. The Ninth Circuit conceded as how we generally lack jurisdiction over the appeal of a TRO, but said that when a TRO possesses the qualities of a preliminary injunction, it is reviewable. They said that because Judge Breyer had let the Trump administration file, quote, extensive written materials and held a hearing, it was basically a preliminary injunction, which, I mean, I guess when you're a federal judge with life tenure, they let you do it. The court rejected the government's argument that only Trump can say if there's a rebellion, reasoning that the issue is one of statutory interpretation, specifically whether the requirements of Section 12406 are met. They even trotted out that Marbury v. Madison quote about it being emphatically the province and duty of the judicial department to say what the law is. But they said they were bound to show a high degree of deference to the president based on an 1827 Supreme Court case called Martin v. Mott. Mott was a guy who failed to show up when he was conscripted into the New York militia during the War of 1812. When he was court-martialed, he argued that President Madison's order federalizing the militia was invalid, and the Supreme Court said that under the Militia Act of 1795, Congress delegated to the president the power to determine when an emergency existed, and the president holds that power exclusively. Now, counterpoint, Martin v. Mott was very different from Newsom v. Trump. In 1827, the court was considering whether a would-be militiaman could substitute his own judgment about the Militia Act for the president's judgment. Today, we're talking about a dispute between two elected commanders-in-chief, one of whom would ordinarily have legal control over the National Guard in his state. In that instance, it's a little weird to give the president pretty much total deference in his determination of whether the conditions of Section 12406 are met. That takes away power from the state commander-in-chief in a way that seems kind of iffy under the 10th Amendment. Nevertheless, the Ninth Circuit decided that because of Martin v. Mott, it had to give a lot of credence to Trump's evaluation of whether Section 12406 could be invoked. They basically said that unless Trump had federalized the Guard based on no evidence at all, or his decision was absurd or in bad faith, who were they to question him, right? And the Ninth Circuit also said that because the statute does not explicitly give the state's governor a veto over federalizing his state's militia, Hegseth's memo to Newsom's adjutant general was close enough to calling up the Guard through the governor. So the Ninth Circuit voided Judge Breyer's TRO and said that the California National Guard was still under the control of Pete Hegseth. They also set a briefing schedule through August, which means that the oral argument will likely be in the fall, by which time the case will presumably be moot because the California Guardsmen will have been released and sent back home. So end of story, see you guys next time, right? Well, no, not exactly, because remember that issue about the Posse Comitatus Act and how Judge Breyer said, we'll come back to that one at the PI hearing? And the Ninth Circuit didn't touch it either. They said, in opposing the stay, plaintiffs do not press their claims based on the Posse Comitatus Act or the Administrative Procedure Act. Consequently, the parties' dispute about how federal forces are being deployed are not before us, which means that as of this recording, there are still live issues before both the trial court and the appellate court, which is one of the reasons why you wait for the PI and do not take an appeal of a TRO, because procedurally, this is a hot mess now. On June 20th, after the Ninth Circuit stayed the TRO, Judge Breyer held the previously scheduled hearing and asked the parties what they wanted to do now. Obviously, the preliminary injunction was off the table, but the appeals court didn't deal with that Posse Comitatus issue. California argued that it should be able to conduct discovery to figure out whether the Trump administration has violated the Posse Comitatus Act. Specifically, the state wants to know whether the National Guard and Marines are doing civilian law enforcement work. And there's some evidence that they are. The state also wants to know whether there's still a so-called emergency keeping ICE from meeting its arbitrary daily quota of arrests, because if there's not, they're going to argue a separate statutory basis to defederalize the troops. The Trump administration wants not that, and it argues that Judge Breyer doesn't even have jurisdiction over the remaining questions in this case anymore. As of this recording, Judge Breyer has permitted the state to conduct limited discovery, but it's unclear how the case will move forward. I should say that California was entitled to seek en banc review from the Ninth Circuit, which is very liberal on the whole, and it did not. But in the Ninth Circuit, an off-panel judge, that is, one who was not on the original three-judge panel, can make a request to rehear the case sua sponte, that is, on her own initiative. And that's what's happened here with this case. As of now, 4,000 National Guard troops appear to be doing very little besides standing around, emanating an air of general menace and alienating citizens from their government at a cost of at least $134 million taxpayer dollars. But even if they never do anything, letting the president flood the streets of an American city with troops based on a few kids throwing rocks is a terrible precedent. Here's Governor Newsom on the Pod Save America podcast explaining it.
But my sense is this is an even more profound moment than it appears. We're on the other side now, Posse Comitatus, the other side of truth and trust now with the military, turning the military against the American people. That's how people feel out here.
Yep. Once that genie's out of the bottle, it's damn hard to get it to go back in. Thanks, Ninth Circuit. Now, it's particularly interesting to see how the media is covering this. This was a massive story, and it was covered by about 540 outlets, with about 40% of sources reporting from the left, 35% from the center, and 25% from the right. And when you examine the headlines, you see very different frames emerge that shape how readers interpret and understand the events that are unfolding. Headlines from the right are most likely to associate the ruling with the unrest in Los Angeles on the streets, suggesting the courts may have been persuaded by Trump's justifications for taking command of the troops. This is in stark contrast to the reporting from the left, which typically framed the story as a warning of a darker, scarier things to come across every major U.S. city. Then from the center, headlines typically frame the ruling as a battle between Trump and Newsom first, and not a battle over the rule of law. The headlines you read first have immense power to shape how you understand the news, and that's why I like to see the news from as many angles as I can with the help of today's sponsor, Ground News. Ground News is a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. And right now, they're offering LegalEagle viewers 40% off their unlimited access Vantage subscription. Scan the QR code or use the link in the description to get the discount for a limited time. Ground News gathers related articles from around the world and across the political spectrum so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the sources reporting, all backed by ratings from 3 independent news monitoring organizations. One of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. This can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns it or what agenda they might have. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum, like this recent story of GOP lawmakers nominating Donald Trump for the Nobel Peace Prize. It was covered by about 50 news outlets, but only 15% of sources reporting came from left-leaning media, 15% from the center, and 70% from the right. Now, regardless of whether or not this is the type of news story that brightens up your morning, this type of analysis helps explain why we often talk past each other and why some people seem hyper-focused on what to others seems like nonsense or fake news. Ground News is my favorite way to get the news, and as a legal eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code on screen or clicking on the link down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click the link below or scan the code today. And after that, click on this link for more Legal Eagle, or we will see you in court.